This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about a case before the Ninth Circuit where the parties learn that you win some and you lose some, and why the United States District Court should have considered California's Intentional Acts statute before dismissing a claim. California State Grange brought an action as a judgment creditor of a non-party Chico Community Guilds, seeking to recover from Guilds insurer Carolina Casualty Insurance Company damages awarded by the state court. The underlying judgment followed a lawsuit quieting title to real and personal property wrongfully converted by Guilds. Grange appealed the district court's grant of Carolina Casualty's motion to dismiss without leave to amend based on its conclusion that the underlying claims were not covered under its policy. In California State Grange versus California Casualty Insurance Company, the Ninth Circuit Court of Appeals on November 13, 2023, agreed to the district court's ruling in part and sent the case back to the court to another part of the case. Grange had sued Guilds in Butte County Superior Court over the assets of Chico Grange number 486, in which Grange brought several causes of action, including cancellation of deed and quiet title, slander of title, and conversion. On February 25, 2021, the state court entered a ruling granting summary judgment to Grange on all claims. The judgment awarded Grange in relevant part 1, the cancellation of the unauthorized deed recorded by Guilds in 2017, 2, $23,167.50 in attorney's fees related to the slander of title claim, 3, damages for conversion of bank accounts in the amount of $80,697.68 plus $9,307.87 in prejudgment interest, and 4, $1,945.49 in costs. Grange sued Carolina Casualty in the United States District Court, seeking a declaration that Carolina Casualty had a duty to indemnify Guilds under the policy to collect on the judgment for all monies awarded. The district court dismissed Grange's suit without leave to amend. The district courts did not err, according to the Ninth Circuit, dismissing Grange's claim for indemnification as to the conversion damages and prejudgment interest awarded by the Butte County Superior Court as restitution not covered under the policy. In the state court's ruling on summary judgment, the Butte County Superior Court noted that Grange was not seeking title to the other personal property items identified in the complaint, but rather only sought the converted funds totaling at least $80,697.69 in Guild's bank accounts, which in turn was the exact amount awarded. The relevant insurance policy explicitly accepted disgorgement or restitution from the definition of damages covered under the policy. Because the conversion damages and prejudgment interest awarded by the Butte County Superior Court was restitution not covered under the policy, the district court's dismissal as to that claim was affirmed. The United States District Court failed, however, to consider whether the attorney's fees awarded pursuant to the slander of title claim may have been covered under the policy where a wrongful act is defined as including, quote, error, misstatement, or misleading statement, close quote. Slander of title involves the publication of a false statement that, of course, could be negligent or intentional. The district court also failed to consider whether such coverage would implicate California Insurance Code Section 533. Carolina Casualty argued that under such an interpretation, if slander of title is a wrongful act because it includes a misleading statement, coverage is barred under the statute because such an action would be purposeful. Despite Carolina Casualty's contention to the contrary, a willful act does not include negligent misrepresentations within the meaning of Section 533. Because Butte County Superior Court made no finding as to whether the Guild's actions were done with the requisite willfulness, the applicability of Section 533 is thus not really apparent on the face of the record before the Ninth Circuit, because the District Court failed to consider the available alternative basis for coverage under the policy that may be vulnerable to the argument that coverage was barred by Section 533, the District Court should reconsider the interpretive question. That was the finding of the Ninth Circuit. The District Court's dismissal of Grange's claim for attorney's fees was therefore vacated and remanded for reconsideration consistent with the Ninth Circuit's opinion. Because the issue for which the case is now being remanded was not considered by the District Court because it would be futile, the District Court did not err by denying California State Grange leave to amend. In my opinion, the Ninth Circuit, trying to help a plaintiff to recover from an insurer when coverage is questionable, sent the case back to the District Court to determine if the acts of the guilds were sufficiently intentional to bring into the effect California Insurance Code Section 533 or not. If the United States District Court finds it willful, then Carolina Casualty will owe nothing on the attorney's fees claim, and if not, it will owe a few $1,000s. In so doing, the Ninth Circuit makes the litigation a punishment of the insurer who was required to deal with a suit and an appeal on a policy that probably owed nothing, but it will cost more to succeed than to pay off the plaintiff. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you will be given notice of every blog posting, usually 5, sometimes 6 a week, and you will have full access to the more than 4,700 blog postings. You can also subscribe to the videos on rumble.com and youtube.com, and if you do, I'd appreciate it if you click on the thumbs up button on Rumble and on the like button on YouTube. Please tell your friends and colleagues about the blog and the videos and let them subscribe to the blog and videos as well. They're free. But if you or they wish further detail on insurance, insurance law, insurance claims, insurance fraud, please consider for a very small fee subscribing to my Substack publications or my Locals community. Thank you for your attention.